someone forgot to tell the Department of Education that you do not mess with teachers. As anybody who has ever spoken before raising their hand and being called on can tell you, you do not mess with teachers. And they also neglected to mention that free speech is more than just a buzzword, and if you tread on it, you're going to get the ACLU involved, and you do not want to piss them off either. Today, March 5th, 2025, the ACLU and the National Education Association filed a lawsuit against the U.S. Department of Education's new anti-DEI policies. If you remember, and I don't know how you could have forgotten, on February 14th, the Department of Education issued what's called a Dear Colleague letter, threatening federal funding cuts for educational institutions nationwide for engaging in diversity, equity, and inclusion efforts, and a 14-day window before appropriate measures would be taken. The lawsuit challenges the government's actions on 4 key legal grounds. 1. Violation of the free speech protections in the First Amendment by prohibiting educators from teaching about race, diversity, equity, and inclusion. It also broadly bans DEI programs, including student groups and faculty associations, coercing educational institutions into self-censorship through the threat of losing federal funding. But did you know that federal law prohibits the government from dictating what's taught in higher education, and that it's against federal law for the government to dictate curriculum in K through 12 education? Against the law. Well, nobody told the Department of Education that. Second, violation of the Fifth Amendment's right to due process because the letter fails to define key terms and practices. For example, what qualifies as DEI? Can history teachers talk about slavery? How about the Trail of Tears, the Holocaust, the suffragette movement? None of that's been defined by the Education Department's letter, and so teachers are being forced to avoid important discussions in history, English literature, and more for fear of risking losing federal funding. And because the guidance is so vague, there's no real way of knowing what is and what isn't allowed. Number 3, violation of the Administrative Procedure Act. The letter imposes new legal obligations without any process or justification. There's a process to changing existing federal regulations, and the Education Department just overstepped its authority and ignored decades of legal precedent as well as its own prior guidance on civil rights law. It failed to explain why it's now reversing course on long-standing principles of equity and inclusion that have been part of education for decades. And number 4, misrepresentation of the Supreme Court's 2023 ruling in Students for Fair Admissions v. Harvard. That decision only addressed race as a formal admissions factor in higher education, but the Department of Education has taken to extending that ruling to ban curriculum, student groups, DEI programming, or race-neutral diversity initiatives. Last I checked, only a judge can do that. And I'm sure that this one's going to be hashed out in court, and I'm going to keep you posted as it does.